I need permission to share my video. Can the host please start my camera as well?
Who's the host?
Hi Deepu. Hi Shirin.
Hello, hi.
Hi, we are just about to start. I guess
Okay.
the host has to give us rights to start our. Yeah, we are live. Yeah.
Okay.
Yeah, great. So, good evening to each and everyone attending this session. My name is Deepu Krishna, and I head the admissions at BITS Law School. It's a pleasant evening. It's raining in Mumbai, and we all probably, at different parts of India also are experiencing the Indian monsoons. And during this evening, I am accompanied by two of my colleagues, both professors at law. They both teach at BITS Law School. They are a part of our team, which will be mentoring, teaching, and also creating, future lawyers at BITS Law School. They both would be very instrumental in the same because both of them come from the background of social sciences. And in the morning, I met some students whom I was saying that law is the crown of social sciences or else humanities. And being a law student myself, I have felt that, the theories and the philosophies which were taught to me in the first year, which probably were very boring to me in the beginning. And I was thinking, what is happening? But later on, when I started reading jurisprudence, when I started reading criminal law, when I started reading family law, I understood the great significance of these things. And this session of ours is, when I'm accompanied by these two professors, they are pioneers in the field. They are the ones who have done a lot of research. They have a lot of publications about how or what I was just suggesting. And this entire session is where I'll ask them a few questions. And being students who are going to join us for the coming days, we thought that it's always important to have a discussion where I ask them some questions. You also ask them a few questions. So the modus operandi of the entire session, I want to make it very clear. It's very simple. Um, I'll be asking them few questions, and then I'll take questions from students as well. This session is purely an academic session. So I will not be entertaining any question regarding admissions or anything else. So you have academic questions, please ask in the chat box. And what I'll do is I'll pick up those questions and I'll start asking each of them. Okay, so that's exactly how we are going to move forward with. We're already a bit delayed, so I'll straight away head to the question. And our first question is something which is interesting and which first year students like you should be very, very attentive when it is being answered. The question goes like, how would you define the term law based on your current understanding? And how do you think it influences our society? Yeah.
Right.
So, yeah, I think any one of you can initiate to answer the same, or should we go ladies first and ask Shireen to answer?
Let Chinmay go first.
Okay.
Okay. Hi everyone. I can't see you right now, but I hope you're all kind of doing well. Let me introduce myself quickly. My name is Professor Chinmay Deshmukh, and I'm an assistant professor here. For the first semester, I'll be teaching law of torts. But my research and teaching interest areas broadly are public law and legal theory. So that's where I specialize in. And when Deepu kind of suggested a topic, law and society, I immediately kind of agreed to it because, uh, and let me connect this with the question that Deepu asked. What does law mean? Because that itself is a very contentious question, really. Philosophers and jurists have been trying for millennia to come up with a very single contained idea or definition of law, but that hasn't been possible. So you can have multiple meanings of law. So one of the very generic examples would be any norm that regulates or controls human behavior. So that can be a very general idea of law. But again, there are kind of different perspectives which find some faults within this definition. They have their own perspectives. And I feel that's where we really try and understand or realize that law can never be a unidimensional field. It can never be a very monolithic concept, but it has to relate to or connect to many other disciplines, right? So if I have to give a very simple definition, I would say law is any normative behavior or any normative injunction that regulates human behavior, but then you also have to look into its context. How does it connect to society? How does it connect to politics? How does it connect to economics? How does it connect to human psychology? And once you kind of connect to all these disciplines, then probably you can start to get a more wider perspective that kind of encompasses many different notions that law touches on. Given the fact that law is all pervasive, starting with the bus ticket that you buy in the morning till the purchase of your MacBook that you did probably, right? Everything is regulated by law. So it's very tricky to contain the definition of law in one single sentence. And that's where I think the context of law becomes very important.
Yeah, if I can add to that, so I'm Shireen, and I will be I'm a sociologist, and I'm an associate professor at Wits Law. And I mean, as a sociologist and as people who study society and human behavior, and when I listen to Chinmay talking about law as norm that controls human behavior, the question really that comes to my mind is, say for instance, norm can come in from various sources, right? So one is a legal source. Other sources could be religious sources, theological sources, authority, right? Priests and etc. Right? These have all been traditional forms of sources through which norms that govern society have come into being. Right? And so there's a very interesting, and there's a way in which how society has developed, what society is, has and how society has thought of itself in terms of state, in terms of a nation, in terms of rules that are universal, that govern each one of us, devoid of our religion. It doesn't matter what religion we belong to. It doesn't matter what strata of society we belong to. It doesn't matter what gender we belong to. We're all considered equal, having our own sense of dignity, and law is a sort of a projection of social progress and social development, right? And a different kind of norm from the kind of norms I first spoke about, right? And I agree with Chinmay when he says that law cannot be thought of it in a very unidimensional way, because law is not just about the text itself, not just the wordings of what should be done and what should not be done. It's also so much about interpretation. It's also about conflicts within. It's so much, and it's so open. It's constantly so, and there's a way in which law and society are so linked. So the society that has given rise to law, and it is law that will give direction to society. When social norms need to be changed, it's law that comes in and actually makes those changes, right, within society. And so therefore law is also something which is it's never fixed. It's labile, it's open, right? It's and one can't study law in a closed room, One can't study law in a chamber. One has to study law as society evolves, as as we evolve as human beings, as our problems evolve, right? Whether it's technology, whether it's climate change, whether it's environment. So law speaks to its context in that way, right?
Can I just add to that
Yeah.
quickly? So, Shireen talked about different dimensions of law. So maybe, think about it this way. What if your father prohibits you from doing a particular thing? Let's say you can't buy a particular shirt, right? And you have to follow it, right? You can't go beyond that authority. So is that a law? Or let's say yesterday we had Ashadi Ekadashi. Now, you couldn't have particular food, right? You're only supposed to have, let's say, some sort of food. And your, family ends up following it. Is that a law? Or um, there is a famous study by two prominent economists, Richard Thaler and Cass Sunstein, and they talked about nudge theory. So what they did was they guided human behavior through particular tricks. Um, and so that people ended up doing a particular thing. So for instance, in a library, they would have these small footprints that led to a particular section of books. And most of the people eventually ended up in that particular section. Now it's controlling human behavior. All these examples that I've given, they're controlling human behavior. Do we qualify them as law? Do we call them law? Or is law something that only comes from the parliament? Where do we draw the line? Our Supreme Court often draws from religion. Does religion constitute law? I think all of these are very open-ended questions that we still continue to debate and argue over. And that really captures the kind of, the scope, the magnificent scope of the thing that we called as law.
Excellent. I'm taken back to the days of my law school. I remember in the very first class of sociology, our professor walks in and he gives us this scenario where he says that there is this village and all of a sudden there are flash floods. Nearly 98% of the population, they are wiped out. And from a family, a grandfather survives. From another family, a husband survives. From another family, the wife survives. From another family, the child survives. Now, can these guys come together and form a society? What will be the emotional issues? And we were thinking, what is he teaching and why is it and how is it connected to law? But later on, when family law was taught to us, when each and every branch of law was taught to us, we started connecting the dots and we were like, wow, this is exactly how it works. So, yeah, society, the moment you say, even if it is a small society of an apartment, even if it's a society as a community, law is very much prevalent there. And that's what makes us lawyers very mature, because at your young age, when you'll be in the very first year, you'll start understanding the concept which many elders are still struggling with. Great. So now the next question is, what does it mean to go beyond black letter? Now, this is one sentence which has been often debated, that law is just a black letter. It is just written. Many people don't even understand that what is the context of written words and why is it called as written words. So the question is, what does it mean to go beyond black letter in the context of law, and how does it differ from a traditional legal analysis?
Okay, so let me explain what black letter law means first of all. So in a common law, so there are two systems of law broadly over the world. There is a civil law system and there is a common law system. Now, combining these two systems, typically the understanding, and that takes us back to the first question, where does law come from? Now, the answer that modern legal thinkers have given, which is under debate, is that law comes from your parliament. Law comes from your judicial diktats, right? Your judicial decisions. So any kind of act, legislation that has been enacted by the parliament, or any judgment that has been given by the Supreme Court, High Court, or different judicial bodies, that constitutes law, right? We also teach students how to read legislations, how to read case law, but that is only one dimension of law. That's what we refer to as black letter law, right? Law that is printed in a textbook, law that is printed in your government gazettes when they publish laws, when they come out with laws. So black letter law is law that has been published, law that is as it is, right? The body of law that has been published, that is passed by the legislature, that has been given by judiciary. But that itself will never be enough. So traditional legal analysis, if I can put it very simply, goes this way. Suppose there is a tort law issue. Suppose someone has assaulted you, someone has hit you. Now, how do you kind of go about analyzing that situation? You first analyze the issue. Someone has hit me. This constitutes the tort of battery, right? Then you say, where do I go looking for the law? I'll either go look for legislation. I'll go either look for a case law. That's what my black letter law is. That's where I'll find laws. This is something, by the way, that you learn in your first semester, how to go look for the law that is relevant. Then what you do is you apply that particular law to the issue that you identified. So someone has hit me, they've probably committed tort of battery. What are different laws and what are different judicial opinions that talk about a particular thing? Is the situation that I'm in similar to the situation that was given in those earlier cases? If that is the case, then that particular rule will apply to my circumstances, and that will give me a sense of whether someone has committed battery, the tort of battery or not, and whether I can claim remedy in a court of law or not. But that's only about the black letter law. That's what we refer to as traditional legal analysis. This method is popularly known as IRAC method, IRAC. Issue, rule, application, and conclusion. You find out what the legal issue is or the factual issue is. You find out what the rule is. And by rule, we typically mean black letter law, what the law says. Then you apply that rule to that issue and then you reach your conclusion. But as you'll discover, as we explore more cases, as we explore more subjects, you'll realize that this analysis is often, most of the times, inadequate. Let me give some examples. Think about a recent case that happened. I'll give you a very interesting example. Recently, a few years back, you guys have probably heard about intellectual property rights. So what it means is if you've written something, then nobody else can copy that without your express authority, without your express authorization. Now, what happened was a particular photocopy shop in Delhi University, what it was doing is it was kind of creating these course packs. So it would Xerox certain books from prominent publishers from Oxford or Cambridge, and it would kind of Xerox these books and give these course packs, right? Now, if you look at the copyright law, the very text of copyright law, it will qualify as infringement. You're taking a book, you're not kind of taking authority or permission from Oxford University Press or Cambridge University Press. You're copying that book and you're passing it off. Therefore, it would, under the simple definition of copyright, it would constitute a violation of the Copyright Act. But then the case wasn't as simple. If you read the case, if you go back, and it became a huge issue because these big publishers, Oxford University and Cambridge, they filed a suit against a simple Xerox copy machine owner, right? A very simple small shop. And it became a national issue because the text of law says, yes, it's copyright. But when the court went into that analysis, it also looked into what is the dynamic between developed nations and developing nations. Developed nations have very easy access to these resources. In India, our law students, not just law students, but university students generally struggle with access to good textbooks. We simply don't have enough money. So given this context, does applying copyright law in its very strict sense make sense in India? Or should we have some exceptions when it comes to developing nations? So court did not simply look at the rule and apply that rule. But what the court did is it went beyond the simple black letter law. It looked at the situation of students in India. It looked at the situation of that Xerox copy machine owner. It looked at what are the fair use. Is using copyrighted material inside classroom, should it be an exception because it is meant for a legitimate purpose? So going beyond the traditional legal analysis, what the court did is that it looked at the entirety of circumstances, the political, economic dimensions of it, and then gave its verdict and said that no, this is not a case of copyright, but it actually falls under fair use exception. So this is the difference between a simple black letter analysis of law and a contextual analysis of law.
If I can just come in there, Chinmay, your whole DU or Delhi University publisher case that you spoke about. So if if we train, if you study sociology, you study political sciences, you study history, and you study it in a strong foundational sense. When you study law, one of the things that you will be aware, say in relation to this particular case, is this question of what Chinmay spoke about, right? Access, right? Which are the groups that have access? The idea of power inequalities. So as Chinmay said, they have to take into account this whole thing about developing countries and developed countries, and see how one particular law will apply so differently to different contexts, because there's such a power inequality. There's an economic, political inequality. And how do we understand this inequality? So for that, we have to go to history, right? And history will take us to the history of colonialism, which will talk about a drain of wealth. It will talk about how there was a systemic um, a systemic imbalance, right, that colonialism created, where you had a culture coming in and doing economic trade and levying taxes and etc., a certain kind of economic system that came about that caused certain countries to become developing and some countries to become developed, right? So all of that historical context, all that political context, that informs the way we think of access, the way we think of power inequalities, the way we think of how different societies are located in relation to each other, such as developed, such as developing. Now, these are terms that we keep using. We feel like we know it. We feel like it's very obvious. But actually, if you take a very historical, political, sociological perspective, it's not so obvious that these countries were not always. We were not always a developing country, right? And it is in relation. It's a Eurocentric idea of what is developed, in relation to which somebody is called developing. And it is a certain political context, a political economy context, in which you've had a history of colonialism, a history of drain of wealth, a history of taxation, entire political context in which this came about, right? So all of that again. So in a small case like this, it would be relevant, right? And so in every case, it will. You never know which political episode, what economic system, what sociological idea gets pulled up, right? And that therefore. This topic, that going beyond black letter law and seeing law as in relation to society, becomes so central and so crucial in the way the way we read law, and the way we approach law, and the way we teach law, and the way we practice law.
Yeah, absolutely. Just today in the morning, I was meeting some student. I was discussing the same thing with them, that how written words or written, law is something which has been so important in the way we live our life also. Because even if there's a small squabble which happens between two people, there is often one guy who will come up with the argument, where is it written? And or as you go to a bank, you have a mess up with the bad manager, you will ask him that give it to me in written,
Right.
write and give it to me. That's exactly how legal systems or philosophy has been able to be a part of our lives. Now the next question is, why is it important to explore philosophical aspects of law? How can the understanding of philosophy enhance our understanding of legal concepts and principles? There might be some students here who might be from commerce background, and they'll be like, oh my god, in BA there are a lot of philosophy, how would I get adjusted to it? But believe me, I am myself a student of commerce in my school, and then I went and did my BLLB, and there was nothing as a difficult which I found, rather it was more interesting. So over to both of you, and I would want you to explain the students that how the philosophical aspect of law is going to help them enhance their learning.
Right. So I can give a three-pronged answer to it. I think philosophy, or the contextual understanding of law, is important for in a personal sense. It's important in a professional sense, and it's also important in a broader social context. For you personally, when you come to a law school, it's not only the law that you study, right? It's not only a journey into the field of law and it's kind of black letter law, but it's also your personal journey, right? You're growing, you're evolving, you're cultivating different aspects of yourself. As you go out, you'll also be a very prominent member of society. So when you have these multiple roles, having this interdisciplinary understanding of law grounding yourself in not just the letter of the law, but the spirit of the law, also helps you grow in that personal space. It also helps you understand the world better and deal with the problems that come in your life better. But more than that, it also has a professional context. Take any prominent example, right, of prominent lawyers. Nani Palkhiwala, for instance. Nani Palkhiwala, we know him as a great lawyer, but he used to conduct these mass gatherings. He used to have these speeches. After every budget, people would look forward to hearing Nani Palkhiwala talk about budgets. I mean, imagine a lawyer, but perhaps more than any economist, people really gathered, and they gathered in thousands and lakhs back in 1970s and 80s to listen to his speeches. So why? Because that guy was expert and he wrote one of the most prominent books in competition law, because he could manage to go beyond simply, let's say, what the constitution said or what the particular area said, but cultivated his interest beyond going simply into the field of law. Think about Fali Nariman, for instance. Um, has written one of the most amazing and most authoritative work in arbitration. But if you talk to him, arbitration will be the last thing that he'll talk about, right? He'll first talk about literature. He'll talk about history. He says his favorite book is Nehru's Discovery of India, and he says it should be made mandatory in every law school. Why? Because having that sense of interdisciplinarity is what sets you apart from, let's say, lawyers who simply have this kind of blindfolds and simply argue from the letter of the law. Because as we were discussing, no case is a black and white, case. It will always involve different dimensions. And the more you explore these other subjects, you're also able to build creative arguments in your written submissions or when you argue in front of the court. And that creativity can only happen through this engagement with different disciplines, right? So both for your personal as well as professional development, this engaging with these different disciplines play a very important role. And lastly, I think socially, um, what is law? Law is something that connects, that coordinates activities of all the community, really, right? It really is the binding glue, perhaps, that keeps our community in that order, in that flow. And if you're not aware of the broader purposes of or the concept of rule of law, for instance, you will never be able to fulfill that function of that broader purpose of law, really. So personally, professionally, and socially, in all these spheres, having this kind of broad understanding of the notion of law and the context of law plays a very important role.
Yeah, I mean, philosophy is so crucial to understanding law. And, law, there are so many concepts within law that go back to philosophy. And maybe Chinmay can, he's being a little modest here, but he can tell us a little more about, I mean, concepts of like the idea of state, evolution of state, democracy. Democracy and law, again, have a love-hate relationship. That becomes so important to understand, right? On the role of the judiciary in both keeping the political power in check, as well as being a check to society. So all of those, right? Law is all about how the direction that society takes. It's a sort of, it could be seen in a hopeful way. It could be seen as a beacon that shows the path, the light ahead, maybe. And philosophy becomes so important to understand all of that, all those the multiplicity, not just for you to be an interesting speaker, and not just for you to be somebody who's good at arguing and all of that, but just for you to understand the force of the task before you, right? So philosophy becomes absolutely crucial. So much of law emerges from philosophy, right? Maybe Chinmay, you can say a little.
I can just give you one example. It's philosophical foundation of law of tort.
Yeah.
Right. So even for law of tort, as perhaps doctrinal a subject, you still have to go. No law book will start without discussing Aristotle or Plato or these kind of classical Greek thinkers. So it's absolutely foundational.
And believe me, philosophy is not just there in law. People like Einstein, people like physicists like Newton also believed in philosophy, and it was basically philosophy which pushed them to think at that level. And philosophy is something which I have seen. The more scholar you become, the more you read, you tend to become philosopher. So the favorite judge of the new generation, Justice Chandrachud,
Yeah.
if you read
Mhm.
his judgments, it's full of philosophies.
Yeah.
He brings out philosophies from the West, from the Europe, and wow, it's a pleasure to read him. And one of those, ex-Supreme Court judges, Justice Krishna here,
Absolutely.
he was
Absolutely.
a pleasure. When you read him, you feel goosebumps at times the way
Yeah.
he's to connect human conduct with the
Yeah.
film. So yeah, that's how it is. It's such an interesting thing.
Yeah,
Um,
philosophy can be hard at first, but once it's sort of you get the bug and you get the excitement, then you're just it's just you see things, it's like an onion, right? You see layers and then layers and
Yeah.
layers,
that's
and
actually
then it's just something you can't do without.
So there's a student who's asking, how does legal philosophy help law students develop critical thinking and analytical skill? How can it contribute to their overall legal education and future legal careers?
Okay. That's a very important question, really. Um, well, I can maybe discuss a few cases, right? And that may give some insight as to how, in many different areas of law, philosophy always plays an important part, and not just philosophy, really, but these theoretical disciplines. Yeah, in your first year, you'll study political science, you'll study sociology, you'll study history, and all of these elements will play a very important part. Now, let me give you a couple of examples. Now, let's think about environmental law, for instance, and one would imagine, how is environmental law related to philosophy or all these concerns at all? But that really is missing the entire point, because our very understanding of our relationship with our environment, and this generation is more attuned to it. And we've constructed this hierarchical dimension. Humans are better, we are superior, and we can dominate, control, or manipulate the environment. And that itself is a consequence of Enlightenment rationality. That was not always the way in which we perceived the world, right? Um, Pre Enlightenment, let's say pre 18th century humanity looked at our relationship with nature in a very different way. But post 18th century, 19th century, with the rise of industrialization, with the rise of excessive emphasis on human rationality, we've made this hierarchical relationship. Humans are better. This is something in philosophy we call it anthropocentrism, right? Keeping humans as the center for entire activity and then constructing law around it. But then scholars said, wait a minute, is this the only position? Is this the only way we can treat environmental law? What about non human lives? So there is an emerging field of animal law now, right? So just as you have human rights, there is also a notion of recognizing animal rights. And then it has repercussions for many different areas of law. You must have come across this interesting case recently where a monkey took a selfie, right? And there was a human who was involved in it also. Now, who really owns the selfie, right? Is it really the human who had the camera, or can the monkey also have copyright over that selfie? And for that, for answering that, you must first answer: does monkey have the same rights as humans do? Why have we kept them beneath the understanding of humanity? Really, why can't they have the same right? And this anthropocentrism is being questioned increasingly.
Yeah.
And you can see these reflections in new legislations vis-a-vis climate change, right? So that's just kind of one example vis-a-vis
I'd
environmental
like
law.
to come in there a little bit because when we study climate change and we do Anthropocene, so that's
Mhm.
the sort of the philosophical term for understanding climate change and everything that it has done. So, and climate change is very interesting because it has completely taken all the disciplines and turned them around, right? Oh,
Yeah.
it's changed everything because it's now saying that. So, what is climate change? Climate
Mhm.
change is really understanding that we always thought of a distinction between the social world and the natural world. They were different. We are humans, those are animals, and those that is the natural world, this is plants
Yeah.
and so on and so on. And what climate change is saying that our actions is actually causing the climate and the
Mhm.
natural world to change in its regularity and the things it does and the kind of rainfalls it gets, and the levels of nitrogen in the soil, multiple, right? It's not just in one site, it's in multiple sites at the same time, right? Compounded. And so that's
Mhm.
climate change. So and if one were to take that seriously, that the human is causing things to happen to the natural world, then that distinction between the human and what animal, what Chinmay was talking about, or the environment gets completely broken down.
Yeah.
And if that thing breaks down, then the question that has to arise is that all our concepts of human rights, all our concepts of subject object, of
Yeah.
human and rationality, all of that gets completely broken down, right? And then we have to rethink the way we've thought of philosophy. We have to rethink the way we've visualized what is human in the human rights. We have
Yeah.
to rethink the way we think of the environment, because here we have the environment which is behaving in this way, and it's behaving in this way because it's human action, right? It's completely dependent on post the industrial revolution and whatever has happened after that, right? So yeah, so go ahead.
Yeah. And exactly. And I can also give, so Deepu, coming back to the question,
Hmm.
how does it help these students? Now, think about contemporary issues that these students will have to deal with. Climate change litigation is one of the most prominent emerging areas. Environmental law, perhaps at the time we studied law, wasn't really as prominent. We studied it because it was perhaps compulsory, we had to. But for this generation, this is really an existential question, and there are increasing cases. So having this understanding, this grounding, this perspective definitely helps them argue better, to write better, to think better. I can also give many other examples. Think about AI and law now. Now, now, I was referring to this book earlier, Law of Thoughts and its Philosophical Foundation. Now, what happens, let's say, if Musk's Tesla self-driving car ends up hitting someone? Now, there's no driver in that car. How do we determine the liability? Now, that takes us back to the question of, are machines conscious, right? What do we mean by the definition of autonomy? And these questions cannot be answered unless you've kind of explored the notion of autonomy as it is explored by Aristotle, as it is explored by Immanuel Kant, and many other thinkers. So many of these issues, be it IPR related issues, artificial intelligence related issues, even sports, for instance. So when we talk about, there is a debate that's been going on. Uh, should we only have two categories when we, in sports law, there are often issues regarding hormonal changes and how does it affect your overall performance. Now, to understand the distinction between men and women, you also have to understand what Judith Butler says about the very notion of gender, and how do we determine who is a man and who is a woman. And that plays a role in that particular competition, in the understanding and interpretation of why do we have these two categories, or should we have perhaps a distinct category. So many emerging areas of law eventually are going back to the foundational questions, the first principles, because they are so new. There's not much black letter law around it. So we have to go back to first principles and think about how to address those questions. Gene editing, for that matter, when you're editing humans now, and a scientist in China has already kind of done some experiments to that end, which was condemned by scientists all over the world. But the question is, it's a possibility. There will be babies whose genes are going to be edited, right? So when we talk about gene editing, we also have to talk about ethics. We also have to talk about its consequences for equality or inequality. So designer babies and broader social context. So in all these different areas, we cannot move forward unless you've developed critical thinking skills. And developing of critical thinking skills can only happen if you are able to absorb, reflect, and think about independently all these different dimensions of these issues.
Yeah. And, when the world is changing so much with new technologies, with gene editing, with climate change, like nothing, what the old world is not, the answers that we had and the models that we have understanding do not hold anymore, right? And I think going back to philosophy then becomes so important, because now we need new tools to think about the world, right? The old tools are not serving us anymore, right? And there's just one place, I mean, definitely one place that we definitely need to go back to make sense of a very different, emerging, very prolific, and where nobody, and where uncertainty is so writ large, right? Like there's risk everywhere. There's nobody with any certainty, and we've all come out of a pandemic, and we all know that nobody has an answer, right? So in that sense, I think better tools to understand the world, updated tools, and for that we have to go to philosophy. And in that sense, black letter is a very outmoded way of going about things.
Great. So there are two questions which I think I'll excuse both of you. I'll quickly answer. By that time, you can have a mini rest. Okay. So there is a student who is asking me, like, psychology is a part of BA program. What is the important aspect for BBA program which will affect the law, and how will it affect it? Psychology is a part of BA program, but we have electives which will be given to you. But psychology is a part where even a BBA student can learn psychology, and believe me, psychology is very important even for a BBA LLB student, because as lawyers we have to be good in psychology also. So yeah, we are not ignoring it, and that will be offered to you as elective, but that is elective. You may either choose to read it or not. Okay. Another student was
But
asking,
I can give one example vis-a-vis that question.
yeah,
And the very famous example is competition law.
yes,
Understand competition law really. Again, when we talk about the text of competition law, it'll talk about certain things: what is collusion, what is market dominance. But to really understand the nuances of these concepts, when you explore these subjects that tell you about what is capitalism in BA, you'll also study about the emergence of free market order, and then its relationship with competition law. Competition law only exists under an assumption that it's a free market society, right? So what does it mean when you say that it's a free market society? And through these BBA subjects, you'll be able to understand these first principles, kind of the more nuanced aspects of it, and that will help you better understand the notion of collusion or dominance in competition law. So that's just one example, but even in IPR, in technology-related laws, many different aspects from their BBA courses will play similarly important role.
excellent. Another question was, according to the website, BITS is still in early stages of negotiation with law firms about internship opportunities. Which law firms have accepted? Now, I cannot name them here, but on the day of orientation, we are surely going to name them. Now, if you're thinking that we will be putting across to you something without doing any homework, sorry, it's not like how it is. We are in talks, and in fact, there have been law firms which have reached out to us, because I'll tell you something interesting. When I was in my law school, there were many internship opportunities which was given to us in Mumbai, but we could not, or we did not come. One of the main reasons was the stay in Mumbai is very expensive. So anyone who was in Mumbai used to come, stay here at his place, and he used to do internships. Now at BITS, we have done something which no other law school in India does, and that is our students, while they will be doing during their internship, will get access to the hostel. The hostel will be open for them. You getting it? Ask any law school, they don't do it. They will ask you to vacate the hostel the moment internships begin, or else the semester gets over. But the dean told me, and I was so happy when I heard it, that our students can stay in the hostel and they can do their internships. So internships are going to get plenty. They won't have that kind of a trouble. And there's a lot of work in Mumbai. There are a lot of law firms also in Mumbai which need students of good law schools to enter. Okay. Now, there is Aman Jain who's also asking, how can we learn creativity of showcasing our case in court, which will help us to fight the case?
Okay.
We showcase our how can we learn to be creative?
Yeah. And how will the course help them to be creative? By the time you guys think about this answer, I'll give him an example of a student of mine who's going to file a PIL, and many dog lovers and pet lovers will hate her for it, but she has a philosophy behind it. What she's doing is she's using Article 21 of the Constitution, which talks about no person shall be deprived of life and personal liberty. She is classifying dogs and pets as persons.
Right, right,
The
right.
river Ganga can be referred to
Yeah,
as
yeah, yeah.
forest can be referred to as person. These pets also have their life and liberty, which pet lovers, and she says she has used a philosophy where she says this is all selfish motives, where they are keeping pets at home. They are not supposed to be because their natural habitat is different. Their paws
Okay.
are not meant to be for, and she has lab reports where she says that you are in fact killing them, and she has a
Interesting.
classification of diseases which the pet is having because of humans. So
Right.
piles and cancer and heart attack. There are many diseases which these dogs are getting due to humans. Now
Mm,
see, look at the amount of research she has done,
mm,
the
mm.
kind of philosophy and psychology and the principles that she has used in her submission is enthralling. I read it and I was like, man, how much did you research? And she said, I am going ahead because I see them suffering. Poor
Mm,
things, they cannot speak, you know.
mm,
And see, this is also an answer to your question about creativity. She
mm.
used her creativity. She went to the labs, she tested, she had blood samples,
Yeah.
of dogs, where she went and she is proving it that this is bad. It is just because you want a kind of a relief, because when the dog or the pet is there, it is your psyche which is getting benefited. What about it? And then
Yeah.
she's comparing it with stray dogs. She said,
Mm,
look at them.
mm.
They are in their natural habitat and they're happy. So, it's upon how you are using this creativity. Yeah, over to you guys.
Yeah, I mean, I can give textbook answers. Again, I have a couple of books that can teach you, perhaps. Right. So there's a very famous book by Glanville Williams called Learning the Law. It's kind of a mandatory reading for a first year law student. Or I can tell you that there are books around clinical legal education that can teach you the art of advocacy. But this is only complementary. What happens is throughout 5 years you will discuss a lot with your professors, with your peers. You'll learn more from outside classroom than you learn from inside the classroom, right? And through this engagement and through your exposure, you have to go outside your comfort zone, have different experiences, go and participate in moot courts, in mediation competitions, in different kind of simulated WTOs. And then you kind of gradually get a sense of what works for me. How can I sort of what is the argument or strategy that I should have? What are my strengths and what are my weaknesses? And it's once you have that self-awareness that you can gradually start refining the skills. So we will be teaching you these skills about how to argue well, how to write well, how to think critically, how to think logically. But it's only through your discussions, through your own experiences, that those sentences, those texts will start making sense to you personally, and you'll organically evolve that ability. But you'll have to put in that work. It won't happen on its own. It's through this kind of mediated exercise that you'll gradually start getting the hang of how to argue well.
Yeah, and I think when we are designing our courses, especially the course that we are looking at, which is we're calling it FOSH, or Foundations to Social Sciences and Humanities, or even the literature course that we are designing. Uh, in- uh, so first of all, we're stitching in three disciplines: political sciences, history, and sociology, and we are trying to creatively approach all the concepts that we think are very fundamental to law. So that's our course. But with literature, I think they are doing something even more creative. They are using YouTube tutorial, YouTube's. They're using theater. They're using poetry. They're using music, right? And they're going to be talking about literature, but also talking about literature and mental health. They're going to be talking about race, class, so all the things that we need to know about society, that knowledge that we need to know, have, but they're doing it creatively, right? So we're thinking of education. And the other thing, maybe I should have said this in my introduction. I'm an anthropologist, and I work on Mumbai city, and I work on landfills in the city. And I have worked in Deonar, which is sort of an area which is sandwiched between the landfill and the slaughterhouse. So we're also thinking of ways in which an experiential form of learning, right, where you can engage with the city and understand it better. and have a more grounded approach to your learning, right? So there's the inbuilt way in which we are thinking of an immersive learning experience, and we're bringing in all kinds of practitioners, workshops. So, and I think when it comes to creativity, it can't be taught, right? If you want to be creative, and if it's something, it's an impulse that comes from within. You can take all the tools that we are providing, and we definitely are thinking of education in a very rounded sense, the term. But finally, what you use, how you use it, and what you do with it, and how creatively you deploy it would be absolutely up to you.
Okay, now there's an interesting question. The attendee is anonymous. I don't know the name, but they're asking, how can we learn about law and its application on human society if we reflect on our 1,000 years of Indian or Indic civilization? Does civilization affect our legal mind, or we just follow the rules set by our colonial rulers and following it?
A very
So what's
interesting
the
question.
first part? Very interesting. What's the first part of the question?
I'll repeat it. What can we learn about law and its application on human society if we reflect on our 1,000 years of Indic or Indic civilization, Indian or Indic civilization? Does civilization affects our legal mind, or we just follow the rules set by our colonial rulers and following it?
Okay, that's a very interesting and very relevant question. Now, don't blame me for this, but I also have another book for this. It's called Rethinking Indian Jurisprudence. Okay. Now, it kind of connects to the exact question that was asked. I don't know, what is the name of the student?
It's anonymous. They did
Okay.
not. Yeah.
Okay. All
I
right.
want to know the name of the student. Please, in the chat box, give your name also, because that's how we can even recognize you, please.
Yeah, but this is exactly the kind of conversation that is happening in law schools, in academic circles, as well as in judicial circles, right? So if you the last two Supreme Court judges before our current judge, they both talked about Indianization of the legal system, right? And what does it mean? It sort of kind of gets to the heart of what does it mean. The very first question: what is law really? Do we really have to follow the British law, which is written in a very archaic sense, or can we now think about law that is more suited to our context? So there is a debate, for instance, I can give you in tort law, right? So tort law, if you go out and ask anyone what is the meaning of tort, chances are 99% of them will not be able to tell you what tort law is. So why not do away with it and come up with a very simple skeletal legislation that talks about civil wrongs, right? That can explain the notion of civil wrongs in a very accessible way to the last person in perhaps the most remotest village of India. And so the scholars are debating, they're saying, if the existing colonial model of tort law is not effective, can we perhaps think about lok adalats, right? And how can they play an important role in how we approach and understand the notion of tort law? So these conversations are happening in terms of the broader philosophy as well, right? What is the civilizational value that can shape and guide the future discourse of law? What is often known as post-colonial discourse, right? Or decolonization of existing structures and categories of law. And in many different areas of law, I think this conversation is already yielding important results. But I welcome the one who has asked the question in this batch to also think creatively and contribute to the answer. It's also our responsibility now. It's your responsibility to think about it. And these are the questions that you will have to answer.
We have a name. They have declared their name. It's Saurav Pathak.
Hi, Saurabh. So I think, there is a conversation that is happening. But if you're interested, you can also contribute to the answers to this conversation. And this is the responsibility that we have as future legal thinkers.
The other thing is that, we need to also maybe think about this idea of an Indic civilization and wonder whether, our the ways in which we look at the past, and we're doing it from the present. And are we looking at it as a sort of a monolithic, and are we looking at it as in this one civilization, one ethos kind of a way, right? And what are the complicated ways? What are the politics of looking at the past, right? These have become also very important questions. But it's a very important point. I mean, I think decolonizing law, as Chinmay said, is something. It's a intellectual task that's been that's been underway. And
Absolutely, I agree with Shirin. I think it's not going to be. I mean, we've only scratched the surface. Once we say we have to decolonize law or think in a post-colonial way, what are we going back to? Is it really a very static, a very certain centralized body of law or norms? And then you start to realize, no, that itself is a very complex and multi-layered and kind of fragmented area. So how do we sort of go further and determine what really is it that we want to retain, or is it really worth retaining? How do we distinguish? So that itself opens way for many interesting conversations. And that's why I said, I think, this generation, I think, will be instrumental in giving answers to these questions.
Right. So, yeah, there's a question. Can you share any personal experiences or observations where the context surrounding a legal issue played a significant role in its outcome or interpretations?
Personal context where, can you repeat the question?
Yeah. The question is, can you share any personal experiences or observations? So there are two things: personal experiences, or else your observations, which you have had, where the context surrounding a legal issue played a significant role in the outcome or the interpretation.
Well, I can give you an example from my own doctoral work, really, because I also thought about the same questions that the students are asking. How can I think creatively about it? And for me too, as Professor Shirin pointed out, it worked organically. So I was thinking about, when I was doing my, when I sort of thinking about what should I be doing for my doctoral work, blockchain technology at the time was very prominent. It still is a buzzword. And then I started to have conversations with my supervisor that I want to do something that kind of combines blockchain technology and perhaps legal theoretical dimensions. Now, the problem was, since blockchain technology itself is a transnational technology, there is no single state or a nation state where this technology is located. I mean, if you want to find Facebook, you can go to California, you can locate their headquarters, and you can perhaps, if you're lucky, meet Zuckerberg. But if you want to meet the founder of blockchain technology, perhaps let's take the very prominent example of Bitcoin. We don't know who the founder of Bitcoin is, but there's a pseudonymous Satoshi Nakamoto, but we don't know who this person is. We don't know where to find the headquarters of Bitcoin technology. It's just transnational. It doesn't exist in any particular jurisdiction. Now, if that is the problem, how do we go about understanding who defines what the blockchain protocol is? If it can't be done through a simple jurisdictional analysis, you can't look at the US and its law and then say that this particular Bitcoin technology is legal or illegal, then what is the way to go forward? And that's where I think, again, the context played an important role. So what I tried to do in my doctoral work is go beyond simple jurisdictions, any particular jurisdiction, but look at the way in which the law of the blockchain, really, who is governing, who is modifying, who is controlling blockchain technology, is determined by something called as spontaneous order, right? So it's not an order that anyone dictates. Perhaps a very interesting analogy would be a flock of birds. When, murmuration of birds, when they make this very interesting murmurations, if you're lucky, you can catch it in, a very nice, beautiful evening as the sun is setting. And, they're flowing organically. There is no order to it, right? Or school of fishes, for instance, or how the crystal is formed. It's not formed by a deliberate order, but it's something that we know as emergent order, right? It's a spontaneously emerging order. And I could utilize this notion of emerging order or emergent order, which is not really a strictly legal concept as such. And then I could apply that to the notion of blockchain protocol governance. Because there is no centralized authority, the authority of blockchain, the law of the blockchain is actually emerging, and there's no jurisdiction which is controlling it, but it's happening in a very spontaneous way. So in that sense, I think having that, interdisciplinarity, because emergent order is something that is well known in science, it's well known in even social sciences, but I could connect that with the notion of blockchain and law and come up with an interesting proposal that the order that emerges on blockchain is really a spontaneous order. So I think that's my personal experience with how these two very different disciplines connected and helped me, perhaps offer an interesting perspective.
I mean, so the question that, how does the context determine the outcome? I think every case it will apply for every case. There's no, I mean, I don't have to give 1 or 2, 3 cases, but I think it will apply for most cases, right? But what's coming to my mind at the moment is, if we look at a lot of the free speech cases, or a lot of when religious communities go to court and appeal and talk about hurt, right? So somebody has played music in front of a temple, or somebody has taken a procession in a different route. There's constantly somebody has made a speech. There's always injury and there's hurt, and so all that, and or somebody has written something that goes against somebody's religious belief, and they're offended, right? So all of those are, sort of very, I don't know, context-based cases. I mean, and that's just one. And like even like say the same-sex kind of proceedings that we've seen of late, right? They will consider Indian morality into question. They will consider Indian family structures. That's why they were making the argument about how a special marriage act should, since we already have that provision, we need to use it. And for those who want to opt out of this structure, give them a different route, so that they are able to get into arrangements where they are also can partake of the safety, the different kinds of institutions that other married couples enjoy, right? So I mean, context is very much part of the outcome, and I would say that's for most cases, all cases, right? So these are a few cases that I just, from talking about, they just at this moment, this is what I'm thinking of, so I'm just saying it here.
Okay, there's another question where, again, if you guys won't give us the name, I have to call it as anonymous attendee. Okay. So an anonymous attendee is asking as an
not give their name. Maybe it's not scary for them to write and ask their questions.
Okay,
it's all right. Yeah.
There's nothing to be scared about. As an MPC student, will it be difficult for me to grasp some topics if I don't have a foundational understanding of those that are given to a commerce or humanities student? I could answer it by saying that I can give you a practical situation. The topper in my batch was an MPC student, and I was a BA student, and she was too good. So there is nothing as such. It's called as law school for a reason, because everything starts from the scratch, and whatever will be taught to you, the foundational understanding will be taught to you. So, there's nothing as such difficult. I would want the professors to comment.
Yeah, I think we are going, when we're designing the initial courses, we're going with the understanding that there will be students from different disciplines. There will be students who may have had no exposure to humanities, social sciences, may have done very different kinds of readings. So we are taking that into consideration. But of course, it is your interest. It is how much, the effort you are willing to put in. And once that has come from your side, if there's interest on your side, and if there is, if you are, true to your own learning, right, then there's nothing that can stop you. Nothing will be a barrier in that sense. But we are taking into cognizance. And we also understand that a lot of you are doing a lot of these law entrance exams. And we also feel that there's a lot of unlearning we need to do, right? There's a lot of, you're already coming with certain ideas of law, and we would like you to unlearn those ideas, right? And so there'll be a lot of unlearning also to do.
From our end as well, we also have a lot to unlearn.
I suppose, and we're looking forward to learning from you, right?
Exactly.
Yeah.
So it's a mutual process of learning and unlearning.
Yeah. I think when Chinmay was talking about blockchain and new technologies, or when we're talking about I don't know, what's the Korean band called? the Korean pop
BTS.
BTS, talk about BTS and Korean dramas, and there's just, I mean, there's a way in which you all know things that we don't,
Absolutely.
right? So that's it.
Okay, there's a very controversial question here. And again, it's like, has studying law ever made you to have deviate from your moral compass?
Oh Lord.
And how do you handle
Studied
scenarios?
law. So I have not studied law. I'm not a lawyer. I'm a sociologist. Um,
And
you
there is
what?
another question. It says that how
What
do
do you
you
mean by your moral compass? You mean my own values, or you mean social values? They are not the same, no?
Mhm.
I mean, society would want. If I were to follow my parents and social norms, I would have been, married and in the US somewhere, being a good, dutiful wife. I'm still, may choose some of those options, but I mean, I definitely would not be working. I definitely would not have gone and done my PhD. I would not have done a postdoc. I would not be here today. And it is because I question some of these social expectations. So what do you mean by moral? I mean, are you talking about social values? Are you
Yeah,
talking
that's
about our,
interesting.
yeah,
that's not mentioned here. So even I can't comment, because for me, moral compass differs from person to person.
No, I can tell you one thing. It does help you stand your ground even if thousands of people are against you, right? If you've thought through, and if you're convinced, and if you have that conviction,
yeah,
then this law school journey will give you that sense of confidence, regardless of what other people are saying or thinking.
yeah,
If you know what you stand for, and if you are
yeah.
certain, then you kind of argue and not kind of succumb to their pressure. So it in fact has worked the other way around. I mean, if I can answer that way.
Yeah.
There is one example which comes into my mind. It is not of moral compass. Again, it is of ethics.
Mhm.
Uh, the legend Nani Palkhiwala, he's like a godlike figure to all of us.
Mhm.
And this incident comes right from his career, where he was defending Indira Gandhi in the famous case.
Yeah, yeah, yeah. He
Then
was
the
just,
day she imposed emergency,
yeah,
he stood
yeah.
up and said, "Get lost. I don't want to defend you, because what you have done is unconstitutional. You should not have done that."
Yeah.
That's my compass to me.
Absolutely.
I can tell you from my personal experience of having lots of women friends who have done law, who are practicing, who are
Mhm.
litigating, who represent women in, say, domestic violence or other kinds of issues, and they are. I think their ability to stand for their politics, stand for certain values, all of that is so grounded in law. It makes it so possible, and I think these women, they really become game changers. They become people who
Yeah,
change the way society thinks, change the way
absolutely.
they affect so many lives. In
Absolutely.
such a meaningful, positive way. And I think law has a very strong role to play in that.
Yeah, yeah. I mean, one of the reasons why I chose the field of law is because I looked up to these people. I
Yeah,
think perhaps the question is also kind of pointing to the in last few decades, the profession of law doesn't have as the reputation that it enjoyed earlier.
yeah,
But if
so
you
true.
if you go before that, really, right? I look up to these people. I admire these people, be it
Absolutely.
Gandhi or Tilak or Nehru or Patel or
Yeah.
Martin Luther King or Obama. I mean, think about these names.
Absolutely, they were game
And
changers, right? And it is through law you've had some of our biggest game changers, right?
absolutely,
And that continues to be the
In fact, I think still there are people like Harish Salve and all,
of
but
course, of course.
and they are jurists. But the problem is, I get very offended when people point fingers at only lawyers. I remember there was an open house where a kid asked me this question, and I became very emotional. And I told him that when a bridge falls, or a flyover falls in a city, no, why doesn't anyone point fingers at the administrators, the bureaucracy, or as the engineer who built it? During
Mm,
Corona, we all remember what happened, right? A simple injection was getting sold by the medical professionals for such
mm.
high rates. Why were people not pointing fingers then? So, there are 2 to 3 lawyers. If they do bad, the entire legal
Yeah,
community So
That's
that's
true.
something where I see the hypocrisy of the society.
Absolutely.
Great suggestion by Batul Shafiq, where he says that please share us with us the list of books mentioned during this discussion. So,
Sure,
Chinmay,
sure.
after this
Sure,
discussion,
sure. Come. You'll be
moreover,
coming here next month, and I'll be more than happy to share the resources
and
with
We
you.
were
moreover,
sitting with our lists, respective long lists.
Yes.
dear students, there is a list of readings which has been shared by all the professors to us, which we'll be sending to you shortly because the month starts tomorrow. So you'll have a lot of things which is recommended by professors, a list of readings and many interesting videos which even I keep saying, So they all are clubbed with me. We're going to send it off to you. So you'll have a lot of things, to read.
But
Okay.
Deepu, I can also share the list of these books that I just showed them, and you can share it with them.
Yeah.
Yeah. Sure, sure, sure. We'll do that. And plus, we'll share the recording of this video also with all students. So,
Okay.
just in case you want to also see the context in which that book was referred, you can also see that. Okay. So we are past 6 and we are running against time. There is few questions which I'll take. So there is this question where a student is asking about school of thoughts. The
Hmm?
student says, we have heard about school of thoughts and how law students become a part of such thoughts. Can you guide us how it takes place and how should we adapt to it?
Schools of thoughts?
So
School of
in jurisprudence, there are typically, the realist school of thought, the positivist school of thought, but that's the traditional way. Let me put it that way. But the approach that we will be following is not really kind of simply introducing you to different schools of thought and then kind of only introducing them doctrinally and that's about it. No, that's not how it works. The idea is for you to discover for yourself,
Yeah.
right? There are 1,000 different possibilities. We can create a mental map really of different, and there are spectrums. I
Yeah.
wouldn't even categorize them as kind of a particular
Yeah.
rigid school of
And
thought.
I think, when I think when seeing all of my colleagues and the faculty here, I don't think there's anybody who will tell you how to think, right?
Yeah,
We will just give you tools and you
yeah,
can think the way you want to think. As long as you have justifications, as long as you are respectful towards other people's opinions,
yeah.
as long as you're able to put forward your point in a manner uh, that is reasonable,
Hmm.
right? Then that's it. We can all have different schools of thought. There's no one school of thought that anybody would expect anyone to prescribe to, right? And so yeah, so I wouldn't worry about the schools of thought. You are free to think in whatever school of thought that you have been schooled in, that you free, and of course feel free to even question this
Yeah,
your received knowledge and received wisdom, right?
absolutely.
So, and I wouldn't really worry about that. You will
I
be
mean,
taught on how to think,
yeah.
right? You'll be taught on how to read and how to question. So you will be constantly questioning. And if there's any school of thought, I think that as an institution we would be promoting. It is the school of thought of thinking, critically thinking, right? So
Exactly.
questioning and questioning and more questioning.
very
Yeah.
well answered.
Can I quote one of my favorite thinkers here? It's Stanley Fish, a very renowned literary theorist. And he says, and I keep this always posted with me, he says, the purpose of a good education is to show you that there are three sides to a two-sided story.
Wow.
So I think that's really the essence. It's never black and white, it's never yes and no or either and or, but there are different perspectives. We will help you introduce and understand different perspectives, but the task of deciding what works best for you and what you want to kind of go ahead with, it's up to you.
Great. So yeah, we have come to the end of the session because we only had a hour's time with us. So thank you so much to both of you for taking out time. And I think the students might have an idea about the approach we have. It was a small introduction to both of you who would be teaching them, mentoring them in the very first year. I could not take a few questions because we have a paucity of time and we have to stick to that time also. Apart
But
from
they'll be here in a month, so please feel free to come to our
that's
offices and
exactly the
ask me the
parting note.
questions.
That's exactly
We'll
the
be seeing
parting
each
note.
other quite a bit.
I would want you to all bring these questions when you come. because it's a 5 year or a long journey. Starting from 1st August, you will have classes where all these topics will keep on coming. And believe me, that's the best part about learning law, because it's not about some formulas or something. It's about us humans, how we behave, legislators behave, how the judiciary behaves. And the most powerful part of it is you get to, like she said, like Shireen said, question them, ask questions and critically think about it. Okay. Thank you so much to all the attendees. Thanks to the professors. See you all soon. Bye bye.
Thank you.
Thank you, everyone.
For sharing this.
Bye.
It's possible. Thank you. Bye bye.